Good evening. I would first like to thank MEDEL for the invitation. It's a great honor for me to be here and speak in front of such a distinguished audience. I would like also to thank Professor Pinto de Albuquerque, who made the contact with me, and to greet my colleagues in the panel, Professor Poes Maduro, Professor De Wert, and Monica. I will draw on my experience on the Constitutional Court, but I must say from the outset that I'm not a specialist in European law. So I will start by addressing the question of the relationship between national judges, or national courts, and European law according to the case law of the Portuguese Constitutional Court. And then I will go on to make some questions on the case law on judicial independence and the base for that case law of the European Court of Justice. I mainly have here questions. I hope that they can be answered by my colleagues, perhaps after I speak. The first point, the more general problem of the relationship between national courts and European law. The approach of the Portuguese Constitutional Court was from during a long time not to address this question directly. There were, for a long time, contacts between the European Court of Justice and the Constitutional Court, asking even why the Portuguese Constitutional Court did not raise any preliminary questions. Well, the approach was mainly to, when the issue arose, to try to interpret, to make an interpretation of the constitution of the parameter and of the norms that are controlled according to EU law, but not directly raise either preliminary questions or addressing the question of primacy of EU law in relation to the national law, including constitutional law. I remember, I think it was the first decision where the Charter of where the court cited the Charter of Fundamental Rights in 2002. It was a decision on the question was the distinction between the right to marry and the right to build a family, the protection of a family non-founded in marriage, and the court said it cited this distinction also in the Charter of Fundamental Rights because, not directly, but because it expressed common principles to the European legal orders. This approach, not even controlling the identity of values or principles as other courts did, was changed by two decisions in 2020. One of them was already cited here by the President of the Constitutional Court. It's the most important one, a decision from the 15th July 2020, 422, where the Constitutional Court recognized it was not competent to control the conformity of European Union law to Portuguese constitutional norms and principles, but made a distinction. It distinguished between a field outside of the fundamental principles of rule of law and democracy, where it accepted control by the Court of Justice, limiting its own jurisdiction. And it then distinguished between cases, between aspects or points where the fundamental principle of rule of law and democracy had not an equivalent, a materially equivalent parameter in the European Union law. It admitted that there could be cases where the parameters were different. It could only, always when there was a norm of European Union law that was to be controlled according to a parameter that had an materially equivalent principle or norm as the one recognized in the Portuguese Constitution, the Portuguese Constitutional Court said it should defer, it should abstain to decide on this issue. It is an important decision on the relationship between the Portuguese constitutional law. It did not affirm directly the principle, but it is obviously that the primacy underlies this decision. Then also in 2020, for the first time, the Portuguese Constitutional Court raised the preliminary question in decision 711/2020. It is a text question concerning the used cars. I will not deepen on this, but this decision from December 2020 also follows this, in my view, at least this change of attitude of the Portuguese Constitutional Court towards European Union law. I will now go on to raise some questions on the case law on judicial independence. I would like from the outset to state that I agree with all the decisions of the European Court of Justice on the Polish and all the Romanian, also in the Romanian laws on decrees on retirement, on responsibility of judges, even on the rules on judicial error. So it's not a matter of substance. But I would like to raise some questions about the basis that was used after the ASGP decision, Article 19(1), which states that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. I will not recall the ASGP decision. As you know, it was, I think, the first decision where the court used this basis to state that every member that it could control according to the principle of effective judicial protection, whether the courts in each member state would comply with this requirement of Article 19(1). Then the court, mostly in the decision Poland, Commission against Poland, repeated this approach from 2019, but I will not, as I said, recall these decisions. I will just raise the question of whether there should be any specific connection between European law and the application of Article 19(1). This was denied, at least as I see it, in these decisions. I would like to recall that also concerning a similar question concerning what counts as implementation of EU law, the court had to decide on the decision Ackerberg-Franzen. I tend to agree with the conclusions of General Pedro Cruz Villão, who stated that, as a rule, it is for the member states themselves, in the context of their own constitutional order, to review, to apply EU law. So the responsibility of the Union for guaranteeing fundamental rights must be examined in terms of transfer. So, an interpretation of EU law that turns the exception into a rule would not be acceptable. As I stated from the outset, I agree with the content of the decisions of the ACG, of the European Court of Justice on this, on the matters. It's not. I'm just asking questions about the basis that was used. So, in these conclusions, it was said that there should be a specific interest of the Union in ensuring that the exercise of public authority accords with the interpretation of fundamental rights by the European Union. So there was a specific requirement, not the simple fact that such an exercise as an ultimate origin in union law, it would not be sufficient for considering that the courts were implementing EU law. The ACJ did not accept these conclusions, at least as I see it, but I would like to end by questioning. There is a tendency to undeniably, because also of developments in some unhappy developments in some countries, that the courts become more involved and are dragged into issues of rule of law, democracy, and human rights. The European courts. That's a tendency I would not criticize by itself, but I think the problem, the basis for that involvement must be questioned and discussed. The question I would like to raise isn't Article 19.1 too narrow a door for the control of the whole judiciary organization of member states to pass and to be transferred to the European Union, considering all the rules on the transfer of judges, on judicial error, on when the court itself recognizes that the organization of the court systems have remained with the member states. The Court of Justice stated that by requiring member states to comply with these obligations, the European Union is not claiming to exercise the competence itself, contrary to what Poland, the Republic of Poland, alleged. But the question is whether there is a sufficient connection with European law. Is the simple fact that a court can apply and will apply European law sufficient to transfer this or to entrust this control to the European Court of Justice, even in all these fields? In my view, this development inverts this rule-exception relationship, according to which it is in principle up to the member states to apply EU law and to set the institutional framework for that. And it raises some strains on European integration. I always am skeptical of attempts to substitute court decisions and activisms for political problems, for legitimacy, transparency reasons. But the problem, and I will end with this remark, I think this development is a substitute for other mechanisms that are not in place and are not used, are not effective. Political mechanisms that should react to these unhappy developments, like measures that restrict judicial independence. I have my thoughts that this should be done by the European Court of Justice. That's what I would like to say. Thank you.